Hi, good evening. This is a Delhi High Court judgment. Citation is Commissioner of Income Tax, International Taxation versus Hyundai Rotem Company. Transfer pricing issue. So, issue before the Delhi High Court was what is the date of receipt of order? When the order uploaded by DRP on the income tax business application portal is not visible to AO. In that case, what is the date of receipt of order? That was the issue. Facts, simply put, HRC is a Korean company, submitted its return for AY 2018-19. The case was referred to TPO. TPO proposed upward adjustment in respect of provision of administrative support service. Then AO passed a draft assessment order. HRC filed objections before DRP. DRP directed AO and the transfer pricing officer to verify the margin computations and rectify computational errors. TPO revised adjustment, and based on that, AO passed final assessment order. Then HRC filed an appeal against this order before the Income Tax Appellate Tribunal. The contention of the HRC, that Korean company, before the tribunal was the order passed by AO is barred by limitation under section 144C(13) of the Act. The submission of the revenue was the manual order uploaded by DRP. It was not visible in the assessment work list of AO, and hence AO was not notified about the same in the ITBA portal, income tax portal. AO did not receive any communication of DRP order, either through mail or on the ITBA work list. It received the doc, that is post, physically on 1/6/2022. Hence, the time limit should be computed from the date of receipt of the post, that is 1/6/2022. The time limit for passing the order is under section 144C(13) is 1 month from the end of the month in which directions are received from DRP for passing the order. The order was passed on 1/7/2022. Hence, the order passed was within time limit. So, the contention was the DRP uploaded the order in the portal on 23/5/2022. But AO had no visibility to that order, even though uploaded on the ITBA portal. AO received the order on 1/6/2022. Order passed on 1/7/2022 was within time limit. That was the contention of the department, revenue. The tribunal allowed the appeal of the Korean company, HRC, Hyundai. Hereafter we will call it as Hyundai. Tribunal reasoned that the order was uploaded by DRP on 26/5/2022. I'm sorry, I inadvertently said 23/5. It is 26/5/2022. Hence, assessment order should have been passed by 30/6/2022, 1 month from the end of the month from which the directions of the DRP was received. So, 30/6/2022, you should have passed an order. But you passed the order only on 1/7/2022, hence it is clearly barred by limitation and hence null and void. That was the tribunal judgment. Appeal was filed against the tribunal order by the revenue before High Court, Delhi High Court. The submission of revenue was till such time the AO received physical copy of the order from DRP. The time it will not start running for completing the assessment because he had no visibility of the order. Only when he received the physical copy of the order, the time will start running. The uploading of copy of order by DRP on 26/5/2022 should not be taken into account as it was not visible to the AO. Delhi High Court said the case is no more res integra. in view of the judgment of Delhi High Court on identical facts in the case of Louis Dreyfus Company Limited, Company India Private Limited, which in turn relied on a Bombay High Court judgment in the case of Vodafone Idea Limited. In Vodafone Idea Limited case, the revenue made it clear that once DRP directions are uploaded with DIN number on the ITBA portal, the same is visible to the AO. So that was the judgment. It is quietly covers this case. Delhi High Court agreed with the submission of Hyundai that the date of uploading of the order of the DRP will be considered as service to the recipient. In the present case, the necessary documents were uploaded on the ITBA portal on 26/5/2022 for the perusal of assessee and the assessment unit or the AO by providing DIN credentials. The submission of revenue, that section 144(b)(2) of the Act, authorizes the CBDT, Central Board of Direct Taxes, to exclude cases which shall not be governed by the faceless assessment scheme. And in exercise of powers conferred under section 144(b)(2), the board, that is CBDT, since the very inception of FAS, faceless assessment scheme, has excluded the application of FAS to cases assessed in international taxation. This was also rejected by the Delhi High Court. Simply put, they said, no, this falls under the exception clause. 144(b)(2) of the Act gives power to the board to exclude cases from the mode of service. So this kind of service will not be accepted as this ITBA portal service will not be accepted as a correct mode of service. So that was the contention of the revenue. This was also rejected by the Delhi High Court. Delhi High Court noted that as per the provision of the e-assessment scheme of 2019, all orders, notices and decisions have to be necessarily uploaded on the ITBA portal. As part of the larger faceless assessment regime, all filed and uploaded directives of the DRP would be construed to be sufficient service for computing the period of limitation. Then the period of limitation has to be computed from the date of uploading of the order, and the AO shall pass the assessment order bearing this crucial date in mind, that is the date of uploading of the order by DRP on the ITBA portal. So Delhi High Court dismissed the appeal of revenue, stating that there is no substantial question of law involved in this case. My comment is simply put, the initial contention of revenue was that DRP directions were not visible to the DRP order was not visible to the AO till the date of receipt of the physical copy of the order. But no serious arguments were advanced in that connection, whether it was visible or not visible. If it is not visible, what is the reason for non-visibility? Sometimes there is a computer breakdown. It can happen. Sometimes, for example, if CBDT sends some order, sometimes it goes to the, in the individual cases, it may not apply to the portal, but individual cases, sometimes it goes to the spam file, folder. So all this can happen. So I thought some reason will be given, but no such contention was given. So what I feel is maybe AO had some cataract problem and hence it is not visible. Just for fun, don't take it very seriously. Then the second contention is my feeling as far as GST is concerned. GST also, they are uploading the order. I am not sure in the income tax whether when they upload the order, date of uploading of order, that column is there or not. In GST, when I saw it, maybe 3 months or 6 months back, when I was handling a case, there was no date for uploading of the order. So what they do is the department, my personal feeling, I may be wrong, but my personal feeling is department what they do in GST matter. I have handled one case. I don't want to disclose the name of the client, but in that case, the period of limitation was completely expired. But what the department has done is they have put the date before the period of limitation and uploaded it in the portal. There no message was sent, no email was sent, nothing was sent. But the order date, if you take, it was uploaded, it was within limitation. But the client said the uploaded order, it was uploaded only after the period of limitation has expired. He was sure about this. So some play has been done by GST authorities, even though we were not able to prove before the court. This contention was submitted, but appeal was not filed or something. So court considered, no, you go back before the authority. They gave an opportunity to the client. But what is the date of uploading of order is clearly, as per the client's saying, is clearly after the bar of limitation, after the date of limitation. But the date of the order is before the period of limitation. So this is also happening in the this thing. I do not know whether that has been corrected by the GST authorities, even though not relevant to this case. I just thought I can share this also with the whoever is hearing this. Thank you very much. Have a great evening. Bye.